Alright, we got a guide to complying with the Petroleum Market Manipulation Regulations. It's 20 pages. Guide to complying with the Petroleum Market Manipulation Regulation Federal Trade Commission. Alright, we'll increase. Guide to complying with the Petroleum Market Manipulation Regulation. The FTC with the Federal Trade Commission staff prepared a guide to help with comply with the anti-fraud provision Federal Energy Independent of the Security Act of 2007, or EISA. The Federal Trade Commission Petroleum Market Manipulation Rules, Section 811 of the Energy Independent Security Act, authorized the Federal Trade Commission to issue regulation prohibiting the manipulative and deceptive conduct in wholesale petroleum market. The Federal Trade Commission Petroleum Market Manipulation Rule prohibited the engaging fraudulent and deceptive conduct, including making false, misleading statements of the material fact with connection with a wholesale purchase, sale of the crude oil, gasoline, petroleum, distillates. The rule separately bans the internal failure of the statement of the material fact when the omission 1 makes the statement misleading, 2 distorts the likelihood to distort market conditions for any product covered by the rule. Section 812 of the Energy Independent Security Act makes unlawful for you to report false, misleading information related to the wholesale price of the crude oil, gasoline, petroleum, and distillate. The Federal Department of the Agency 1. If you're legally required to report information to, but you knew that the responsible should have known that the information was false or misleading. 3. You intended with the false, misleading to affect with the trigger with the data, comply with the department agency with the statistical, with the analytical purpose with the respect of the marketing of the crude oil, gasoline, petroleum, distillates. And over on the side it says, no, on Section Federal Trade Commission Act, nothing is next with the rule shall be construed with the altered standard associated with establishing act, practice, and deceptive, unfair violation. Section 5 of the Federal Trade Commission Act of the Energy Independent Security Act with the rules additional measure that apply to certain products within or in connection with the wholesale petroleum markets. Your Energy Independent Security Act and the Petroleum Market Manipulation Rules do not apply with the retail sale of the gasoline, diesel, and fuel oil, nor do they set with a wholesale price for the covered products. Guide summarizes the rules, answer the commonly asked question, contains with a copy of the rule relevant to the Energy Independent Security Act to help with your business comply. Penalties: violation, petroleum market manipulation regulation. The Federal Trade Commission can sue the violators of the Energy Independent Security Act or the rule of the federal court. The court can impose civil penalty up to $1 million a day for each violation, in addition to the other remedies available. The Federal Trade Commission Act and such in order to stop the legal conduct. Assessing civil penalty for the court shall take into account factors such as seriousness of the violation, efforts of the violator to remedy any harm in a timely manner. The rule prohibits the fraud with the deceptive conduct. Section 317.3 with the prohibits knowingly engaging acts practiced for the course of the business, including making false with a misleading statement of the material fact with a defraud with a deceive any person. Section 317.3 with the rule prohibits intentionally with the bending of the material of the fact with a mission making the statement with a misleading with the likely to distort market conditions for any covered product. Under Section 317.3 with the rule, you may not knowingly engage in any act or practice course of the building, including making the untrue statement of the material fact, operates or would operate is fraud with deceit of it upon any person. Under Section 317.3b of the rule, you may not intentionally fail with the state of the material fact with the under circumstance of the render of the statement that you have misleading the omission distorts or likely distort market condition for any covered price. Example of the conducted prohibited with the Federal Trade Commission rule: false, misleading public announcements, plan, pricing, output, decisions, found misleading statement of the federal, state, local governments of the current inventory of the refinery operation status, false, misleading representative of the price and volume of the past transaction, private price to a private price, reporting service fraudulent and deceptive the transaction side with the sky of the actual liquidity and with the price of the particular assessment of the market for the assets. Initially omitting material for the information for the report, such as for the operational staff of the refinery, terminal, or pipeline that makes the report false or misleading. Intentionally omitting material information about refinery production from the statements to mislead others during an emergency. There are two rules section with the four of the different string with the intent that you must have with when you've acted with the violation. Section 317.3 which cover the over the fraud with the deception, just lying with the sufficient that you knew that it was conducted with a fraudulent deception that you may have known with the conductor will create with a fear of the risk of the defrauding, deceiving another market participant. As a result of the violate the rule, extreme reckless in doing so, create a series of the risk of the conduct would fraudulent and deceptive. The commission may have relied with the direct or circumstantial evidence of the determination if you knew or must have known that you were conducted created such a risk by contract violation section 317.3b, whereas proof of the intent with the defraud, deceive with any of the person that you would intend with admit with the material fact intent to make your statement misleading, mistaken, transmitting false, misleading information to price reporting services would not sufficiently violate each section of the rule. In addition, violation part section 317.3b with the required proof of the misleading omission to distort likely to destroy the market conditions of the covered product. Therefore, the section prohibits only those misleading omission material information that are likely to market information reliable. Alright, section 317.3b with the rule apply with the voluntary provide information compelled with the provide information statute order regulation intentionally fail with the disclose with the material of the fact with the disclose with the information misleading. Rule does not relieve you any other legal obligation to disclose your information. Note, on the bilateral negotiation, the Commission generally does not intend for the reach negotiated between the two parties when there is no broader dissemination of the fault with the misleading information, fraud, and deceptive conduct with a private contract dispute, such as the claim that the contract was entered into the false pretense with an or the party had a pre-existing legal duty to provide information from the contrary party the more appropriately treated under state law, but the rule does not prohibit mistakes unintended with conduct with a legitimate with the conducting undertake with the ordinary course of business. The rule is not intended to disrupt the flow of the truthful information that discourage good faith of the estimate with the uncompleted act. Also, do not trigger the rule with the example of preparing fall with the misleading data with the reporting service was not actually transmitting it does violate the rule. The Commission does not intend to second guess legitimate supply of the operational decision, nor does it intend to set out output with the prices for covered products. The rule does not, however, the prohibited fall with the misleading statement for about supply operational action. Output prices for covered products. Alright, no new conduct record keeping requirement. The rule does not require new and affirmative acts. Specifically, the rule does not create the duty of the supply of the product to provide access to the pipeline terminals or the update with the correct information. The rule does not require the duty to disclose any price volume to other data market participants for the market at large. In addition, the rule does not require you to create, retain, and submit any information. Resolve of the rule does not impose any of the new record keeping requirements. Alright, who must comply, any person including but not limited to individual group, unincorporated associates, limited general partnership corporation, or other business and currently subject to the Federal Trade Commission Act must comply with this rule. Although the Federal Trade Commission Act applies broadly, does not apply with the provide with only in the part with a certain entity that include bank, federal savings, loans, federal credit unions, common carriers such as railroad, pipeline, long distance, telephone companies with airlines when they are engaging in common carrier activity. Question and answer for the I am required to submit reports to the government agency. What if I make a mistake with the information I provided? A. Neither the rule nor section 812 of the Energy Independent Security Act prohibits a mistake. Therefore, no liability under the eve of the rule section 812 for good faith estimate. Question. I operate a pipeline company regulated with the Federal Energy Regulatory Commission as an interstate with a common carrier with its common conduct covered by the rule. Possibility with a certain pipeline company with their activities that may fall outside of the coverage of Federal Trade Commission Act to the extent that they are acting as a common carrier. However, there's some of the pipeline company with their owners affiliated with it involved with as many aspects of the petroleum industry. If your company owners and affiliated with engagement in conduct connection with the purchase for the sale of the covered product, you may be subject to the rule. Alright, indirect involvement of the fraud with the matrix of the rule. The rule prohibits direct and indirect fraudulent deceptive conduct. If the result of the rule prevents from engaging fraudulent deceptive conduct with the where alone with the other through others. For example, if you're trading coverage with the product, you cannot avoid liability under rule for preparing a fraudulent deceptive report having someone else file it. Covered petroleum products. Crude oil existing one liquid phase of the natural underground reservoir that remains liquid at atmospheric pressure for after passing through separate facilities, or to a shale oil tar stands requiring further process for the sale of the refinery feedstock. Finished gasoline, including conventional reformulated oxygenated blends, conventional reformulated gasoline blend stock, oxygenated blending, jet fuels, including commercial military specification jet fuels, diesel fuels, oil not included, number 1, number 2, and number 4. Other products covered in the rule of sufficient nexus between fraudulent and deceptive conduct involving those products with the covered petroleum product with the instant renewable fuel with blending components for the integral overall supply with the finished burner fuels. Thus manipulating the purchase of the sale of these products can affect the transaction for the covered product and may violate the rule. Products not covered in natural gas over the non-crude refinery feedstock, heavy fuel oil, accommodated inputs of corn sugar, which are predominant even in non-petroleum products. Questions and answers. Question. Ethanol produced with the superloaf of the product produces falsely and announces shutdown of the plant creates a perception of the product shortages Shortage of this violation, possibly with the rule prohibits the fraudulent conduct with sufficient nexus for the covered project. The ethanol is important being component for gasoline manipulation with the ethanol prices may be the effect of the wholesale gasoline transaction. Question: I'm a gas station and I pay a negotiated price based on the rack over the gas price for gasoline, which I then sell at my stations. How does this rule apply to my business? A. The rule applies with the rack sales, including the negotiation purchase by wholesale customers like your company. Rule does not apply to retail gasoline sales at the pump. Question: Our airline buys jet fuel. Some of the different suppliers of jet fuel the fuel is delivered and the suppliers directly to our airplanes at the airport. Are their sales covered even though the jet fuel was not resold? Yes, bulk petroleum's purchase of sale of the jet fuel are covered by the rule even if the fuel is not resold. Alright, rules apply with a wholesale transaction. Rule apply with the front end of the deceptive with the conduct of the connection with the purchase with the sale of the crude oil with the jet fuel with the level of the trade with the rules apply with the purchase with the sale, gasoline, petroleum, the distillates over the jet fuel with the terminal rack level, the upstream terminal rack level. The rule does not apply with the retail sale with the gasoline, diesel, fuel, oil, the customer. The rule apply with the conduct in connection with the wholesale with the transaction covered product with the rules apply with the fraud deceptive with the conduct with the connection wholesale with the transaction cover the product with including with the conduct directly, indirectly with the effect with the transaction cover the product that is in purchase with the sale of the crude oil, gasoline, petroleum, distillates at wholesale. The rule prohibits fraudulent, deceptive action whenever there is sufficient nexus between action and purchase of the sale covered in product. The Commission will interpret the phrase broadly to give it the full effect of the rule. Question: Are employed with collective of the data petroleum market of the public serve of the internal forecasting of the reports, the information with the value of our company reply with the make of the business decision? Are we required to share information with a counterparty in a bilateral negotiation with the belief that it would change with the counterparty's business decision? No, although such information may material with the rule does not require the disclosure of the information, even if the company value of the information would have the effect of differently with the type of the information. Next question: Does the rule prohibit the misleading omission that are made with the context negotiating counterparty over the terms of the spot transaction for gasoline? Probably not. Misleading statement that made during the bilateral negotiation unlikely to affect with the integrity of the market discovery that typically not widely disseminated. However, under some circumstances, if the thinly traded market will trade that takes place with the reported markup price is more likely to reflect traded misleading information affect the market price and circumstances making it intentionally misleading statements omitting a material fact violation section 317.3 of the rule because of the statement that may distort or likely to distort market conditions of the covered product. A material fact significant alter for the total mix of the information available to the market participant. A fact of the material of the responsible market participant will be considered the fact that the important making a decision by sell the covered product. It's not enough to simply show with a particular statement that falls incomplete with a misrepresentation of the fact that the otherwise insignificant purchase sale of the decision with the covered practices, generally establishing him with a particular person who have found admitted interesting or would have made a different choice with the additional information they have knowing will not be sufficient for the proof of the rule violation or rule of the violation required by the reasonable market participant will find omitted information material with omitted information is needed for the contemptuous statements for the not misleading notes supplied by the inventory level of information. Market participants pay close attention to changing supply inventory with the false misleading announcements about the supply of the inventory. Refiners especially likely to affect transaction covered products are likely to be material. Alright, the rule also does not entitle the market participants with all the information related with the market transaction material. Omission with the not misleading with the market participant could not reasonably accept to have omitted information. For example, the bilateral negotiation reasonable market participant is not entitled to market intelligence gap of the other party in negotiation. Intentional omission with a material fact that to make the statement of misleading that must destroy the be likely to distort market conditions, cover the product with the market impact with requirement section 317.3b, section 317 B with the rule only prohibited the initial with the omission of the material fact with the statement that distort with the likely to distort market conditions covered the product with therefore section prohibited the only with the misleading omission of material information likely to make the market or information less reliable. The rule does not prohibit the material omission made during routine business activities unless the omission undermined the integrity of the information disseminated with the broader marketplace with the covered product, establishing a violation of 317.3 that does not require the proof of the product with any other special effect with any of the covered product. Question answers. Question. Refinery falsely enough with the display of the shutdown of the refinery maintenance for the benefit of the increase of the near term for the future contract prices of gasoline when the refiner does not actually intend to take with the refiner offline for maintenance does this as such action violate the rule? Yes. The action violated the rule because the refiner is lied about shutting down the refinery for the maintenance, although the false announcement may directly affect the future of the market price if the false reporting would be considered Alright, yes, the action violates the rule because the refinery has lied about shutting down refinery maintenance, although the false announcement may be directly the future market price with the false for the considered in connection with the transaction cover the product because of the higher future prices may induce firms to hold the inventory rather than selling it. Question, is it safe to harbor the exempt future markets the activity of the rule? No jurisdiction of the Federal Trade Commission, the commodity of the future trade and the commodity of future trade commissions may overlap with the complementary with the person involved with the buying some of the future contract with effect with the wholesale purchase sales covered product investigating fraudulent deceptive conduct with the petroleum future marketplace with the Federal Trade Commission with comparably with the commodity future trading commission to avoid duplicative or inconsistent enforcement. Examples, scenario 1, XYZ price service to the collect information refined prior with the transaction with the information calculate the publish the market prior with the trade regularly for the published price for the basic with the trade with the refined prior with the XYZ procedures which are well known throughout the industry require the trade with not to report transaction below specified volume with their intended transaction below with the specified volume to identify with the transaction below specified volume to limit the impact with a small volume transaction reported price. ABC engaged with the trade with the file with the XYZ with the specified minimum volume. ABC report with the trade inadvertently failed to identify with the below with the specified minimum value. No violation of the rule does not apply with the inadvertent conduct with a merit mistake. ABC intentionally report with the below minimum trade that does not disclose because below with the specified minimum volume in order to influence the reported price. The intentional report, although with a literally accurate price, is misleading because of the submitting of the report to ABC leads with the volume trade with the X, Y, and Z minimum reported trade. ABC's action violates Section 317(3)(b with the rule admitted information material with the admission intended to make the report misleading with a misleading omission distorted to likely distort market conditions for the covered product. Scenario 2. Refinery company anticipates a 4-week turnaround when the refinery makes spot with the purchase of the bill of the inventory with the anticipation of the shutdown refinery company with the bill but can announce with the anticipated outage 4 weeks that will be able to continue to sell adequate supply of performing turnaround work if the turnaround lasts 6 weeks. Refinery company output is reduced. Consequently, refinery company needs to make an additional market buys, which result in a local price strike. Refinery company's announcement will be based on good faith estimate. Announcements will not violate the rule of no liability of good faith estimate later turns out to be incorrect. Alright, what to do if you suspect wholesale petroleum market manipulation, information, possible illegal activity, law enforcement official target would violate if you information regarding activity may violate the rules section 812 of the Energy Independent Security Act with the information MMR at ftc.gov. Please know that the email is not secure. The email is not secure. If so, you have the confidential information. Do not send it by email. Instead, please mark it confidential and send it in regular mail. Office of Policy for the Coordination Bureau of Competition, Federal Trade Commission, 600 Pennsylvania Avenue, Northwest, room in the 383, Washington, D.C. 22058-0. Other agency the authority prohibited private the market manipulation, including the Committee of Future Trade Commission, Federal Energy Regulation Committee, the Security Exchange Commission. You may wish to contact with this agency for further information about market manipulation authority. Joint conduct by competitive effect with the marketplace for the coverage of the product may violate antitrust laws. Antitrust laws generally prohibited agreements among the competitors if the raise or lower to stabilize price with the other competitive terms of the trade. When buyers make choice for the buy with the products over the buy with the should accept with the prices of those products that have been determined freely on the basis of supply to demand, rather than by an illegal agreement among competitive with the antitrust prohibiting collect with the conduct such as the price fixing, bid breaking, and market division, customer allocation. If you have the information regarding anti-competitive joint conduct by competitive effect with the market price of the Trade Commission for the least conduct, the Federal Trade Commission, antitrust at Federal Trade Commission.gov. Please know that the email is not secure, so if the confidential information do not send an email, instead please mark confidential, send it to the regular mail to the above address. Alright, Energy Independent Security Act 2007, the Title 8 with Improved Management Energy Policy. Subtitle B, Prohibitions of the Market Manipulation, False Information. Prohibition, market manipulation, unlawful any person with directly and indirectly, either employed with the connection, purchase with the sale of the crude oil, gasoline, petroleum, distilled with the wholesale, manipulative, with the deceptive, with the contravention of such rules, regulation, Federal Trade Commission as may be described with the necessary purpose of the public interest for the protection of the United States citizens. Section 812 of the Prohibition, false information, unlawful any of the person report information from wholesale price for the crude oil, gasoline, petroleum, distillates, Federal Department agency of the person know that the reasonably should have known of the information to be false and misleading information required to be law to be reported. Person intended the false, misleading data with the effect of the data comply with the Department agency's statistical analytical purpose of the respect. Market of the crude oil, gasoline, petroleum, distillates. 813 enforcement of the Federal Trade Commission. Enforcement subtitle shall be enforced with the Federal Trade Commission, same manner with the same means with the same jurisdiction applicable to the terms of the Federal Trade Commission Act, Title 14, United States Code 41 intent sequence, were incorporated and made in part of the subtitle violation of the treaty of the unfair of the deceptive act of the practice violation provision. Subtitle should be the treaty of the unfair deceptive act practice prescribed under the rules issued under Section 18A1B of the Federal Trade Commission Act, Title 15, U.S. Standard Code 57A1B, Section 814, Section 814 penalty, civil penalty, additional penalty under the Act of Federal Trade Commission Act, Title 15, U.S. Standard Code 41 intent sequence. Any supply of the violates 811 and the radio 12 with the punishable civil penalty not more than $1 million. None of the penalties provide subsection A shall be obtained with such manner civil penalty imposed within under Section 5 of the Federal Trade Commission Act, Title 15, U.S. Standard Code 45. Multiple offense mitigating factor for the assessing penalty provided in subsection A. 1. Each day with a continuing violation considered with a separate violation. 2. The court shall take into consideration one factor considered with the violation. B. Efforts to person committing the violation remedy with the harm caused by the violation in a timely manner. Section 815 effects with other laws, other appropriate authority of the Commission. Nothing is in subtitle limited effect with the authority of the Federal Trade Commission being efficient with the act enforcing action taken a measure of the Federal Trade Commission Act, Title 15, U.S. Standard Code 41 intent sequence, or any other provisional law. Antitrust laws. Nothing in the subtitle should contribute to modify, impair, supersede operations of any antitrust laws for purpose of the subsection. Anti-trade laws shall have the meaning given to the subsection A first class of the Clayton Act of the Title 15 U.S. Standard Code 12, except that includes Section 5 Federal Trade Commission Act 15 U.S. Standard Code 45 to the extent that such Section 5 applies to unfair method of the competition. State law. Nothing in the subtitle permits any state law. Alright, Title 16 CFR Part 317 Prohibition Energy Market Manipulation Rules Scope of Definition Prohibited Practice Preemption Servability 371 Scope of part of the subtitle B with the Title 8 of the Energy Independent Security Act of 2007, the Public Law 110, 140, 121, Statute 723, codified with the Title 42, U.S. Code 17301 through 17305. Rule applies to any person provision. Federal Trade Commission Jurisdiction, Federal Trade Commission Act of Title 15, U.S. Code 41. Definition. Following definition shall apply for the rule. Crude oil means the mixture of hydrocarbons exhibit one liquid phase with the natural underground reservoir remains liquid atmospheric pressure after passing through separate facilities of shale, oil, tar sands, rather than processing for sales of refinery feedstock. Gasoline may be finished, including but not limited to conventional reformulated oxygenated blends. Conventional and reformulated gasoline blend stock oxygenated blending can only mean for the person must have the known his or her conduct fraudulent to sub the person mean with the individual group of the unincorporated association individual and limited to the general partnership corporation other business entity from distillates 1 jet fuel included not limited to all of the commercial military specification jet fuel 2 diesel fuel oils included but not limited to number 1 number 2 number 4 diesel fuel number 1 and number 2 number 4 fuel oil. Wholesale means all purchase of the sale of the crude oil with the jet fuel, all of the purchase sale of the gasoline, petroleum, distillates over the jet fuel, add the terminal rack with the upstream of the terminal rack level. 317.3 with the prohibited practice for the unlawful person directly indirectly connection with the purchase sale of the crude oil, gasoline, petroleum, distillate, wholesale of knowingly engaged any of the practice. Of course, business and including making the untrue statement of the material fact of the operates would be the operate with the fraud or deceit with the upon any person. Intentionally failed to state with the material with the under circumstances rather than statement made with such person misleading, providing that such admission distorts, likely to distort, make market conditions of any of such product. 317.4 preemption. The Federal Trade Commission does not intend through obligation with its rule to preempt laws of any state, local government extent with any such law conflict with the rule. 8 allows in conflict conflict with the rule if it affords equal greater protection with the prohibited practices set forth in 317.3. 317.5 Severability. The provision of the rule separate severable from one another. Any of the provisions state with a determined invalid is the Commission's intent that the remaining provisions shall continue in effect. Alright, and that was Federal Trade Commission, United States of America, FTC, November 2009. And that was Guide to Complying with the Petroleum Market Manipulation Regulations.